Hello friends, a very good morning to this virtual business law class. Now in my earlier videos, what I have done is I have given you brief introduction of each act. There are 5 acts in the syllabi of BCom Honors. The first was ICA 1872, second one Special Contracts, third was LLP Act 2008 and fourth was Sale of Goods Act 1930 and the last was Introduction to IT Act 2000. So in the last 5 video classes, I've given you brief introduction of each act. So in my today's class, I'm going to begin with the very first act, which is the Indian Contract Act 1872. So friends, in this act, I will be dividing the entire chapter into 3-4 lectures. Lecture 1st, Lecture 2, Lecture 3 and Lecture 4. And I tell you that this is Indian Contract Act 1872 is the lengthiest one. And since the students do not study this at 11th class law paper, so they find it quite difficult. In the first chapter particularly, they find some terms very difficult. But I would like to advise you through my long experience of teaching in Delhi University that you must be very, very clear about the concepts. Because in law paper, you have to write examples and then case laws. And if you are very clear about the concepts, then you will find it very interesting. So friends, be very clear about the concepts. Clarity of the concept is very, very important. So I hope that this will give you a great learning. My video classes will give you a great learning. And if you have any problem, write in the comment section and I will definitely reply to your queries. So friends, you all know the very first chapter under the Indian Contract Act 1872 is nature, meaning and kinds of contract. So this I will be dividing into 4 lecture classes. In the first lecture class, I'll take up meaning and essentials of contract. Then in the second class, I'll take up one statement. And in the third, I'll be talking about kinds of contract. And in the fourth lecture, I will discuss some distinctions because some distinctions are very, very important. So the very first heading which I'm going to take up is, the meaning and essentials of contract. There is a very important statement in this chapter. All agreements are not contracts, but all contracts are agreements. This is a true statement. So 2 terms I have used here. One is agreement, second is contract. Normal person or the layman does not understand these 2 terms. He may find that these 2 terms are the same. Out of these 2 terms, one is the agreement and second is contract. But these 2 terms, they cannot be used interchangeably. One is not the synonyms for another. So these 2 terms are different. So in my today's class, I'm going to explain what is agreement, what is contract, and which agreements can be known as contract. There are a number of authors who have defined the term contract. Salmont, William Anson, and then the definition has also been given under the section 2H of the Indian Contract Act 1872. Now, as per section 2H of ICA 1872, contract is an agreement which is enforceable at law. So the term contract is equal to agreement plus enforceability. But when we talk about agreement is a sum total of 2 terms. One is offer and second is acceptance. Offer plus acceptance is equal to agreement and agreement plus enforceability is equal to contract. I would like to repeat the statement. All contracts are agreements, but all agreements are not contract. So this statement I would like to discuss under 2 parts. Part 1 is all contracts are agreements. and second is all agreements are not contract. All contracts are agreement because a contract has agreement has some essentials which have been provided under section 10 of ICA 1872. 11 points are there, and those 11 points I'm going to take up in this lecture class. All the points I'll take up one by one. So the first part I would like to repeat: all contracts are agreements. So an agreement which possesses all essentials which have been provided under section 10 of ICA 1872 is known as contract. And coming to the second part, all agreements are not contract. Friends, the term agreement is wider as compared to the term contract. There are so many agreements. Every agreement cannot be termed as contract. Agreement may give rise to the legal obligation, social obligation, moral obligation, but agreement giving rise to the legal obligation only can be termed as contract. Now you may ask, what is the meaning of social obligation? Social obligation is, say, father says to the son who is appearing for CA examination, if you qualify CA, I'll get you mobile. Now, say friends, fortunately, the son has qualified CA. But father, it is not necessary that if father doesn't give him a car, then, son is going to file a suit against the father. So this is a very good example of social obligation. But an agreement should give rise to the legal obligation. That is why, we say the term agreement is wider as compared to the term contract. Now, friends, I would like to talk about the various essentials of valid contract. As I've told you earlier in the beginning of my lecture class today, that an agreement is known as contract which possesses all essentials which have been laid down under section 10 of ICA 1872. So the very first point is offer and acceptance. Now, what is offer? Now, when a person expresses willingness to another person to do some act or to abstain from doing some act with a view to obtain the assent of that other person, he is said to have made this offer. This offer term has been defined under section 2A of ICA 1872. Now, what is acceptance? The person to whom the offer is made, when he gives his acceptance thereto, then offer is said to be accepted. So the term agreement is the sum total of offer plus acceptance. So what is offer? What is acceptance? Say A has given the offer to sell his mobile to B person, and B gives the acceptance. So then we'll say there will be an agreement between A and B. So what is offer? What is acceptance? When I say there are 11 essentials of valid contract, then there are first 7 chapters. They pertain to the essentials of valid contract. Like second chapter is on offer and acceptance, third is on consideration, fourth is on capacity of parties to contract, like this. So all chapters I'll discuss in detail, and if you have any problem, do write in the comment section and I will definitely reply to your queries. Now moving ahead, friends, the second point is an intention to create legal obligation. Every agreement cannot be termed as contract. If the person has the intention to create legal obligation, then only that agreement will be termed as contract. That is, if one person, say agreement takes place between the two parties, A has not performed his part of obligation, then B has a right to drag him to the court of law and he can sue against the guilty party. There are two parties involved. One is a guilty party, the defaulting party, and second is the sufferer party, aggrieved party we may call, or sufferer party or innocent party. So can the innocent party file a suit against the guilty party? If she or he can, then we will say that here the agreement will be known as enforceable. So the term contract is the sum total of two terms. One is the agreement plus enforceability. because every agreement is not enforceable in the court of law. Earlier I have given you the example of social obligation, where you know that in case of social obligation, social obligation agreement giving rise to the social obligation is not at all enforceable in the court of law. So it is must, not only agreement is enough for contract, but it should also be enforceable. Now again, repeating that definition which is provided under section 2H of ICA 1872, contract is an agreement which is enforceable at a court of law. So this is all about the second point. The third point is consensus ad idem. This is a law term which means there must be identity of mind. The parties must agree upon the same thing in the same sense. If there is no identity of mind, then in that case we will say that that agreement will never take the shape of valid contract. Then the fourth point is lawful consideration. The point is, what is consideration? Consideration is a technical term which is used in the sense of quid pro quo, which means something in return. And this something in return should also be valid. It should also be legal. Smuggling of goods, murder, kidnapping, all these are the examples of illegal consideration. So friends, not only agreement must be supported by consideration, but it should also be legal, it should also be lawful. Then the next essential is free consent. Two or more persons, they are said to consent as per section 13 of the ICA 1872 when they agree upon the same thing in the same sense. Not only consent should be there, but consent should also be free one. Free consent has been defined under section 14, which provides consent is said to be free when it is not caused by coercion, undue influence, fraud and misrepresentation. In detail, I'll be talking about all these terms in the respective chapter. So, if there is no free consent, then the resulting agreement becomes voidable contract. Void contract, voidable contract, illegal contract. All these terms in detail with the help of examples I will discuss under the heading, kinds of contract under the very first chapter. Now point number 6 is object, legality of object. Every agreement is entered into with some objective, and that objective should also be legal. Now when I say that seller has given the proposal to the buyer to sell his laptop, then what is his objective? He wants to sell the goods. And what is the objective of buyer? Buyer wants to buy the goods. So friends, remember that every agreement is entered into with some objective. And whatever is objective should also be legal. Law does not permit that one should commit the murder of another or kidnapping, cyber crimes and all. Here objective is not legal, it is illegal. And not only consideration should be lawful, but objective in the agreement should also be lawful. There is 6th chapter regarding this legality of object or consideration. Then the point next to this is certainty in an agreement. Certainty of terms in an agreement. Terms should also be certain. We all are buyers. We go to the market, unless and until we tell to the seller which item we want to buy. Say a person is, a brand loyal person and he doesn't mention the brand to the seller. Then seller is not bound to supply any item to the buyer. So we should be very clear, buyer should be very clear in his mind which item he wants to buy and how much quantity he would like to buy. If he doesn't specify, then the terms are not certain. Then the seller is not bound to supply any item to the buyer. So terms must be very, very certain. I would like to make this point clear by taking the example. Say a person is grocery, shopkeeper, and a customer goes to him and says, "You provide me 5 kg of oil." Which oil? Or 1 packet of oil. Which oil? Refined oil or mustard oil? Which oil? No, it means the terms are not certain here. Now, on the other hand, if the person is exclusive, dealer of mustard oil, and customer goes to him and says that particular brand of mustard oil, and customer goes to him and he says, "You supply me 5 kg of oil." No terms are certain, because when he is exclusive dealer of particular brand of oil, then which oil the buyer wants to buy, buyer need not specify. So friends, terms must be very, very certain. The next essential of valid contract is possibility of performance. The act must be capable of being performed. If the act is not capable of being performed, then in that case, that agreement will remain agreement only, that will never take the shape of valid contract. Say a person who has already died, he cannot be made alive. Technology has progressed a lot, but not to that extent. The person who has lost his life, other person cannot put, life into the deceased person. So, friends, counting of all stars in the sky, counting of all leaves in the tree, or driving your car on the surface of the water, it's not possible. Act must be capable of being performed, and if it is not capable of being performed, then in that case, that agreement will remain agreement only. Now, coming to the next essential, which is the agreement should not have been expressly declared as void. There is 7th chapter, which is on void agreements and contingent contract. Long list is given. About 12 to 13 points have been given under this chapter, where agreements have been expressly declared as void. Void means unenforceable. Now, for example, agreement in the state of marriage, agreement in the state of trade, agreement in the state of legal proceedings, wagering agreements. So these are some of the points which I will discuss in detail under chapter number 7, which is entitled Void Agreement and Contingent Contract. Then the next point to this is legal formalities. There are certain legal formalities which are to be fulfilled. Sometimes document has to be in writing. There is no oral bill of exchange. It has to be given the written form. And bill of exchange is one of the negotiable instruments. It has got 2 parties, or it may have 2 or 3 parties. The person who draws the bill is known as the drawer, and the person upon whom the bill is drawn is known as drawee. So buyer is not able to make the payment to the seller. He makes a request to the seller to draw a bill upon the buyer. So at the request of the buyer, seller draws a bill upon the buyer accepts the bill, and then he returns it to the seller. And the seller has got 3 options to exercise. He may retain the bill with himself till the date of maturity, or he can get it discounted from the bank, or he can endorse in favor of endorsee. During endorsement, there are 2 parties involved. One is the endorser and second is endorsee. So friends, and then there are some documents which must be registered. When we talk about registration of LLP, registration of company, then there are some formalities which are to be fulfilled. So there are some legal formalities which are to be fulfilled. If they are not fulfilled, then in that case, those documents or agreements will not be valid. Now, partners of the proposed LLP are not going to get certificate of incorporation from the ROC, Registrar of Companies, if they do not fulfill the legal formalities. So friends, I have covered all 11 essentials in my today's class, and now I would like to conclude that statement. All contracts are agreements, but all agreements are not contract. So when this statement form question is asked, it should have a good beginning and it should be well concluded. So if statement form question is asked, you write in the very beginning that this statement is true statement. But before we and then you discuss two parts the way I have discussed in my today's lecture class. And then after that you write all essentials and then conclude, because every statement form a question should have a good beginning and it should be well concluded. So after writing all 11 essentials which are given under section 10, you can write that now it is clear from the above that all contracts are agreements, but all agreements are not contract. Only those agreements will be termed as contract which possess the above explained essentials of valid contract. So friends, it is all about for this heading essentials of valid contract in this lecture class. I hope you must have and you will enjoy this great learning, and if you find any problem you can write in the comment box and I am always ready to reply to your queries. Do like my video, do subscribe to my channel and press on the bell icon to get more notifications of my videos. Goodbye friends, we'll meet very soon.